Members, we now come to the Parole Amendment Bill. And the question is that Part 1 stand part. Kelvin Davis.
Thank you, Mr Chair, and it's a pleasure to talk on the Parole Amendment Bill, and I'd just like to preface my opening comments by reading from an article from Mana magazine, an article by a reporter, Aaron Smale. The article's called Inside Out, and it looks at the reasons why Māori tend to be incarcerated more often than they should be. And there's just a quote or a reference to Judge Sir David Carruthers that I'd like to read out. And Judge Sir David Carruthers has worked in virtually every area of the system. He's been the Chief Youth Court Judge, the Chief District Court Judge, the head of the Parole Board, and is currently the Chair of the Independent Police Conduct Authority. And it says he well knows from his time at the Parole Board that parole is often portrayed as a risk to the community, but the whole purpose of parole is to reduce the risk by managing an offender's reintegration into society. The alternative is to simply kick them out of the gate without any of those support structures in place. The international research shows that release on parole is something like 4 to 5 times more successful at preventing reoffending than automatic release at the end of the term. And I think that's a very apt start to the committee stages of this bill, Mr Chair. This bill, it requires the board, when it declines to release an offender on parole, to specify when the offender will next be considered for parole. And the bill also gives the board, that is the parole board, the power when it is setting the date of the next hearing to identify any milestones relating to the risk of the offender. And that's a great segue into the first clause that I would like to touch on, this whole risk milestone that there was referenced in the bill's digest. They've removed that term risk milestone from the bill and have replaced it with what they call relevant activities. So a relevant activity is an activity or a program for the rehabilitation or reintegration of offenders that's specified by the board. The term risk milestone, I think, was too much of a negative term, negative connotations, saying that prisoners had to pass certain milestones. If they didn't, they were at a bit of a risk. And I think that, Mr Chair, that's rightly been corrected, and relevant activities is a better terminology, which are, as I've said, are programs for rehabilitation or reintegration. And you may ask, what would programs for rehabilitation or reintegration into society look like? For example, there are drug and alcohol programs that are available for prisoners. Now, when prisoners go into prison now, they're assessed for their needs around whether they have a drug or alcohol problem, and they're given these programs to address that need. And Mr Chair, it's appropriate that these drug and alcohol programs are there for them. There's also employment activities, participation in employment training, so that they can actually be prepared for the release into or reintegration into society, and hopefully reduce their risk of offending, Mr Chair. I'd like to move on now to Clause 5, which is Section 13A, which has been amended. And funnily enough, this is about epidemic preparedness. Now you wonder, what on earth has preparedness for an epidemic got to do with parole? Well, funnily enough, if there happens to be an epidemic, swine flu or pig flu or bird flu or man flu or whatever epidemic there is going around, prisoners are entitled on their release date to be actually released straight back into the community, released back. And it would be inappropriate for something such as an epidemic to stop people from being released on the appropriate day. And if you have a parole board meeting, there's people from around the country come in and have the right to attend the parole board meeting. And if they happen to come from an area where there is, Mr. Chair,
Kelvin
where
Davis.
there happens to be one of these epidemics, such as the swine flu, whatever, there's facility here for that parole board hearing to actually not go ahead in the usual form, but instead for documents and documentation to be the basis for which the board makes its decisions. And I think that that's fair because, as I've said, we don't want people to be denied the opportunity to be released on the appropriate day that their sentence ends. I mean, I know that there are organisations in New Zealand, such as the Sensible Sentencing Trust, who wouldn't care less if people were locked up and the key thrown away and none of their needs were ever addressed. I think that that's a very sad indictment on the sort of society that those people wish to live in, where they really don't care about the imminent rehabilitation and reintegration of people into our society. Mr. Chair, section, sorry, just lost my position here. Section 14, Mr. Chair. Sorry, section 14, which is around standard release conditions. So a standard release condition is the conditions where an offender who's subject to release conditions must comply with the conditions. And after section, clause 14.3, a new section 5A is inserted. However, the release conditions are around, for example, when a person, an offender is released, they need to report to a probation officer not later than 72 hours after their release. And you can understand why that is needed. They were released from prison, they need to see their probation officer to make sure that they are adhering to any conditions. The offender must notify the probation officer of his or her residential address, obviously, so that they could be checked up where they're living to make sure that they're living in an appropriate place. The offender, another standard release condition is that the offender must not move to another residential address in another probation area. So if they're released to one probation area, they just can't up and move into another probation area and set up shop there without the probation officer knowing. And if they actually, they can apply for that, and if the probation officer actually gives them permission to do so, they may move, and then they need to notify the new probation officer in the new probation area that that is actually the case, Mr. Chair. So there are all these sorts of standard release conditions that they must adhere to. A few others that they must adhere to is if the probation officer is directed that they don't engage with any specified person, and you can understand that. And there might be somebody who would be a bad influence on the offender, or who may have been involved in the crime, or maybe a relation or relative of the victim of the crime, that they're not to go near those or associate with those people, and that's another appropriate release condition. So, Mr. Chair, the part that is included, it says for and this is part 4, that's clause 5A4, for the purposes of any provision of this Act relating to the imposition of standard release conditions, these conditions must be treated as if they were imposed by the board, meaning that even though the probation officer imposes the condition, they must be treated as if it is in fact the parole board that has imposed these conditions not just the parole officer. So the parole officer is acting under the direct line of the parole board, Mr. Chair. Mr. Chair, as we go through and debate this this bill, there's going to be a number of further clauses, obviously, that we discuss, and we get into the nitty-gritty of it. So I'll leave my initial contribution there, and I look forward to contributions from other members around the House. I think that we really do need to address the parole. These amendments so that we do actually make sure that people are released into the community, they are rehabilitated, they do have opportunities for education and upskilling and growing before they are released into the community.
Point of order, Jami-Lee Ross.
I seek leave for the Parole Amendment Bill to be taken as one question.
Leave is sought for that purpose. Is there any objection? There is none. The question then is that parts 1 and 2 and clauses 1 to 3 stand part.
Mr. Chair.
Jacinda Ardern.
Thank you, Mr. Chair. It's my pleasure